other judge, I thought she was better. The other judge we had yesterday, I thought she was better. She was good. She did a good job. All right.
All rise. Courtroom 805, the state of California is now in session. Honorable Judge Butwell presiding. Welcome, ladies and gentlemen of the court. You may be seated. Today we begin with opening arguments. Closing arguments. Closing arguments are the counsel's recap of the case. Defense, are you prepared to give your closing argument? Swear in the jury. Bailiff, please swear in the jury. Got it. Please rise. Raise your right hands and repeat after me. I do solemnly swear. Listen to the facts and the evidence presented before me in this case, and to base my decision solely upon the facts and the evidence. Please be seated. As I said earlier, closing argument is a recap in the counsel's own words. Defense, are you prepared to give your closing argument?
Yes, sir, I am. Ladies and gentlemen of the jury, over the past 3 days, you have heard a lot about facts, and you've heard many testimonies. But one fact still remains. My client, Brad Stevens, is charged with assault with a deadly weapon. Yes, he did assault Mr. Mann, but he didn't because of the words that Mr. Mann spoke to him. Words that he can't remember. How convenient. But let me refresh your memories. He said that if I see you again, the next time I see you, I'll beat you up. Ladies and gentlemen, that's a threat. Mr. Stevens remembered those words, and he remembered them so clearly that the next time that he saw Mr. Mann, he decided to hit him. He had no choice but to hit him. He was in fear for his life, and that's why he hit him. Testimony from the witnesses say that Mr. Stevens has a really good record. He's a nice, quiet guy, and he's never had any reason to be violent. So what reason would he have to hurt Mr. Mann? Fear. Fear is what drove him to pick up that 2x4 and hit Mr. Mann in the face. Now the prosecution is trying to paint a bloody picture of what happened that night, trying to make Mr. Stevens look like a show-off in front of his girlfriend and look like he didn't know what he was doing. But he did know. He had no mistake recalling what happened in that arcade, and he spoke very clearly and was very confident about his testimony. Mr. Mann, on the other hand, he forgot a few factors. Number one, he spoke very rudely to Mr. Stevens, telling him, "Hey, jackass, go play Donkey Kong." And second, the choice words that he can't remember. But Tanya Morgan remembers. She was there, and so was Mr. Stevens. Ladies and gentlemen, this whole case boils down to one simple thing. A guy threatens to beat you up, you get scared, and you get him just before he gets you. Self-defense. Brad Stevens did just that. He wasn't going to let Mr. Mann have the best of him a second time. He had already sprained his wrist. He knew that when Mr. Mann pushed him, that he was very capable of carrying out his deadly promise. As the jury, your job is to put all these facts and testimonies into perspective and to use the education that you have and your brilliant minds to come up with a verdict of 2 words: not guilty. Thank you.
Prosecution, are you ready to give your...
Yes, Your Honor. First of all, I'd like to commend the defense for that nice speech, but stupidity is what caused you to hit my client. Not fear, stupidity. Let me recall the night of June the 4th for everyone. 4 innocent couples claimed to have went to an arcade to play a video game. 2 involving Martin Mann and Connie Cook, and 2 Brad Stevens and Tanya Morgan. Now, it may be true that he did played this video game first, and he did run out of money and had to go get change. But as they say, quote, finders keepers, losers weepers. And these are two high school kids that are very familiar with that tune. They know how the song goes. So if one person comes somewhere and nobody has occupied it, then it's the other person's turn. Now, the fact that he hit him because he had his girlfriend and he pushed him down, nah, he's not going to be rough. He's not going to do that type of stuff to me. Fits this man, dressed in black like a psychopath. And may I recall the first time...
Your Honor, the jury's opinion of the witness has no bearing on their decision.
where's
Sustained,
the-
disregard the last
He can
statement.
do that to my... Oh, well, you know what? I know that.
Okay.
late?
Only, they're not allowed to do it if it has stuff to do with the case that was brought out in the case. What he has on was not brought out in the case, so they can't do it.
Okay, see, I didn't know that. Okay, well, I'm going to go into my fact sheet from everyone that's been on this stand in the past 3 days, meaning Tuesday, yesterday, and today. As we know, he's been accused with assault with a deadly weapon, which is the Penal Code 245. And to bring you up to speed, assault with a deadly weapon means to hit someone with an object without consent, that could cause bodily injury or harm, possibly death, to another person with an object, this object. And Brad Stevens did come up to the stand, and we did ask him his opinion on whether or not this could possibly cause death. But after I'm looking at this stick, and if I hold it in the proper position and wait behind a door for the appropriate person to show up and hit them with as much force as I could, as many times as I could, it could kill them. Comas kill people. If you hit someone hard enough in the head, it's gonna knock them out, put them in a coma. Usually they don't wake up. In some cases they don't. But my client was hit once, and the cartilage was busted in his nose from this man. Now I'm gonna talk about the defense's witnesses. Okay. Cindy Berg, who is the manager of the Big Wheel Bike Shop, brought out by the defense in her opening statement that he was the manager of the arcade, which was a mishap. He was not manager of the arcade. He was manager of the bike shop at which this man had worked. Now, at first he was a stock clerk and was promoted fairly fast to sales clerk, but I felt that that was totally irrelevant. People can know who you are inside your school and inside your job, but your outside life, they don't have to know who you are. You can put up fronts. It's really possible. Miss Barty, when Sheila, my co-counsel, went up and spoke to her on the stand and asked her, did she think she'd permit perjury to protect somebody? And she said that she didn't, or that she wouldn't commit perjury. Most people say that they wouldn't. Many people probably wouldn't. But if it fits a circumstance and they can get out of anything, then they would do what they could to get out of it. Tanya Morgan. She was on the stand, didn't even know how long she'd known him. First she said 2 days, then she said some months, then she said, I don't know, just when we
Objection,
dated.
Your Honor. Again, the jury's opinion of the witness has no bearing.
Overruled.
She's a character witness. I felt she'll say what she can to save him, but little did she know that that set him up. Because she did not know him, she wouldn't have known possibly what he could do. She said that he didn't force his way between Martin and the video game. She was unsure of that, but we found out from testimony, even him himself said that he did force his way in between that game. And I first didn't know what Mr. Mann said, but had made something up later, meaning that by, she said that Mr. Mann didn't say anything to him, but we've already proven, yes, he did call him a jackass and told him to go play a different game. That was true. But of course she didn't know that. But then later, oh yeah, I remember. Brad Stevens, finally. He said he knew Tanya for about 2 months. She said she'd known him 2 or 3 days. And he was full of fun and games. He was up on the stand. He had us all baffled. He had us laughing. He had us entertained. the way he wanted us to be. This case isn't funny. What he did is not funny. Striking a man with a 2x2, I don't think it's funny. This wallet and this knife, I don't care if I'm 13 feet away like my co-counsel was outside, and if the lights were dim, I could tell the difference if I had 20/20 vision between a knife and a wallet. And I'm pretty sure, since it has been testified that they do have good vision, that they can also. And last but not least, the lawyers. Sophia, one of the defense counsel in opening, she said that the defendant, Brad Stevens, was struck. But it might have been a miscalculation in what she read. But Brad was not struck. He was pushed, of course. But one thing that comes to mind, if he was pushed hard enough to sprain his wrist, how could he have that much force to hit him in the face? Then, too, I thought about something else, ulterior motive or premeditation. He was standing behind that door, claimed he didn't know if he had seen Milton Man coming outside. But when I thought about it, I said, anybody could have came out that door if he didn't see him. Now, if he accidentally swung, the manager could have walked out, some other couple could have walked out, he could have hit them. So it had to be premeditation. He had to know that it was Mr. Man. Now, the fact being that after he hit him and he dropped the stick and he ran and was caught is because he didn't have anywhere to turn to. He admitted when he pushed in between Martin Man and the video games that he was wrong. And I think, and I'm pretty sure you agree with me, that if someone does wrong, they should definitely be punished. And he has committed a serious wrong. The facts that I brought to you in the beginning of this case spoke about the fact that he hit my client, Martin Man, that he ran away after hitting him with this stick. Assault with a deadly weapon. Facts have proven it, testimony has, so has evidence. Excellent questioning by co-counsel and proof that this man is guilty. And I'm pretty sure you guys can justify between what is right and what is wrong and know that what this man did was totally wrong and find him guilty because the burden of proof lies on the prosecution. And we have proven exactly what I said in the beginning, what we have proven. Thank you.
Jury, let me remind you what your duty is, and that is to weigh the facts and evidence presented here, and to fairly, without bias or personal opinion, come up with a approach to verdict. David, Bailiff, please take the verdict to the deliberation room.
Go out that door and around and carry there's 2 tables set up. Take the stuff with Okay, it's customary at this time for the prosecution lawyers to stand up, come on over here and shake hands with all the defense lawyers. The fight is over. Now it's in the hands of the jury, and you guys should be relieved. And you both did a great job.
Right now?
Yes.
Order in the court.
Gotta get your shoulders squared. I know y'all ain't forget my wallet. They won't be eating lunch.
No.
Awfully happy. Bringing you up on target now.
Women of the jury, please stand. Do you have you reached a verdict?
Yes, we have, Your Honor.
What is that?
Guilty.
Very well. Members of the jury, please stand and state your verdict.
One at a time.
One at a time.
Guilty.
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 What I'm talking for.
You said what?
Okay, guilty.
It's a unanimous decision. Very well. Brad Stevens, you are sentenced to 6 months in jail, in the county jail, and a fine of $3,000.
3,000 months.
Court is adjourned.
Good. You candy good? Good.
That's it. Where's my point?
Where's my phone?
Master right here said guilty.
Hey Malik, see you in about 6, pal. All right.